Hi everybody, we're from Common Law Assent, sitting in sunny Glastonbury on the bough of an old beech tree. I think it's an old beech tree, but I don't actually know. It's really beautiful here today and this is a lovely spot. So we're going to carry on reading from Albert Burgess' Layman's Guide to the English Constitution. There's a very short chapter here. We're on, is Parliament sovereign, or Parliament is supreme? And then it goes on to Parliament and the common law. So we're going to stop after like 2 pages and then carry on, because there's like a second part to this chapter. Parliament is supreme. Parliament is sovereign, or is it? If true, this would amount to surrendering the crown in Parliament all the rights and liberties to of the people. It is, of course, natural for politicians to hanker after power, and it's often stated, power corrupts, absolute power corrupts absolutely. Power corrupts and absolute power corrupts absolutely. We have a Parliament which claims absolute power. It was, as we have seen above, the Declaration of and Bill of Rights that left the authority of kings as it had always been under the law, contracted to us by the Coronation Oath. However, politicians have opportunistically awarded themselves unlimited powers in its place, to the extent that they claim that Parliament can do as it pleases. Blue-eyed baby boy concept, see above. We've done other chapters, so you can tune into the rest of this on commonlawassent.com or Patreon. We'll put the links below. The political classes have misused their skills and cunning to sideline the Constitution that limited their powers. So we now have an untenable situation where the public are faced with politicians who seem to subscribe to a new doctrine of the divine right of politicians. They have done this by stopping our teachers teaching about the Constitution. A breach of the limitation of the Crown in Parliament would be contrary to the law of Parliament. A breach in the limitation of the Crown in Parliament would be contrary to the law of Parliament. The first Earl of Chatham, Pitt the Elder, was aware of the threat when he said, instead of the arbitrary power of a Stuart king, we must submit to the arbitrary power of the House of Commons. If this be true, what benefit do we derive from the exchange? Tyranny, my lords, is detestable in every shape, but none so formidable as where it is assumed and exercised by a number of tyrants. My lords, this is not the fact, this is not the Constitution. We have a law of Parliament. We have a statute book and the Bill of Rights. So that was the Earl of Chatham, Pitt the Elder. No doubt it was the French Revolution that encouraged this power grab, but also this idea was predated by William Prynne, who postulated the sovereignty of Parliament. It was then enthusiastically taken up by Professor Dicey in 1885 without lawful authority. It is this concept, more than any, that has led to the widespread view that we now live in an elected dictatorship. With the strangling of the House of Lords, the removal of royal assent by the monarch, and general savage control of elected representatives by the use of the whips, the executive is now virtually free to do as it wishes. Sheep down there. Parliament...
Sheep everywhere these days.
Parliament is not sovereign. It must abide by the rule of law, which includes the Bill of Rights. This is by Albert Burgess' book, and you can find it in the files of our group. So anyway, Parliament is not sovereign. It must abide by the rule of law, which includes the Bill of Rights. Betty Boothroyd in the House of Commons in 1993, in reply to a matter of breach of privilege raised by Tony Benn, stated, I am sure that the House is entitled to expect, when the case referred to by the Right Honourable Gentleman begins to be heard on Monday, that the Bill of Rights will be required to be fully respected by all those appearing before the courts. So then we're on to Parliament and the common law, and I'm just going to leave it there.
Let's go to the next spot.
Okay, thanks for tuning in.